Mississippi is one of the most landlord-friendly states in the country when it comes to lease termination, and the process here is fast and straightforward. As we discussed in our habitability video, Mississippi does not have a comprehensive residential landlord-tenant act, so termination is governed by a combination of Mississippi Code Title 89, Chapter 8, which covers landlord and tenant relations, the state's eviction procedures, and the terms of the lease agreement. Let's start with no-cause termination. For month-to-month tenancies, Mississippi requires either party to provide at least 30 days written notice before the termination date. The notice must be given at least 30 days before the end of the rental period. The notice should be in writing, identify the property, and clearly state the date the tenancy will end. For fixed-term leases, the lease expires at the end of the agreed term without additional notice required. Mississippi does not impose any specific advance notice requirement for the expiration of a fixed-term lease unless the lease itself contains one. If the tenant remains after the term expires and the landlord accepts rent, the tenancy converts to a periodic arrangement, typically month-to-month, under the same terms. For week-to-week tenancies, 7 days' notice is required from either party. Now let's cover termination for cause. And this is where Mississippi's landlord-friendly framework really stands out. For non-payment of rent, Mississippi has one of the fastest processes in the country. The landlord must provide a 3-day notice to pay or vacate before filing for eviction. Under Mississippi Code Section 89-7-27 and related provisions, the landlord delivers written notice giving the tenant 3 days to pay the full amount owed. If the tenant pays within 3 days, the notice is void. If the tenant doesn't pay, the landlord can immediately file for eviction. Mississippi's 3-day window is among the shortest in the nation, and once it expires, the court process moves quickly. The landlord files a complaint in justice court, or county court depending on the jurisdiction, and the court issues a summons. The hearing is typically scheduled within a matter of days, making Mississippi one of the fastest states from notice to initial court hearing. Here's something that makes Mississippi even more efficient for landlords. The state does not provide a broad statutory right of redemption for non-payment. In many states, the tenant can pay the full amount at any point during the court proceedings and stop the eviction. Mississippi's framework doesn't guarantee this right. While a judge may allow the tenant to pay and remain at their discretion, there's no statutory entitlement to redemption once the notice period has expired and the case has been filed. This gives Mississippi landlords more certainty in the eviction process. For lease violations other than non-payment, Mississippi's approach depends heavily on the terms of the lease. Because the state lacks a detailed statute prescribing cure periods and notice requirements for specific violations, the lease agreement is the primary governing document. If the lease includes provisions for termination based on specific violations, including the notice required and whether the tenant gets an opportunity to cure, the landlord can enforce those provisions. In the absence of specific lease language, the general approach is to provide the tenant with reasonable written notice of the violation. What constitutes reasonable depends on the nature and severity of the issue. For minor curable violations, like unauthorized pets or noise complaints, providing at least 14 days for the tenant to correct the problem is generally considered reasonable. For more serious violations, shorter notice may be appropriate. For violations that are not curable, or for conduct so severe that continuing the tenancy would be unreasonable, the landlord can pursue immediate termination with appropriate notice and file for eviction. Courts in Mississippi generally support landlords who act reasonably and can document the violation. For criminal activity on the premises, Mississippi allows landlords to pursue eviction aggressively. Drug-related offenses, violent crimes, and conduct that threatens other residents or the community are all recognized grounds for termination. Mississippi courts treat these cases seriously and typically move them through the system quickly. The landlord should document the criminal activity and provide written notice to the tenant before filing. Mississippi has a specific provision addressing drug activity that's worth knowing. Under state law, a property where drug manufacturing occurs can be declared a public nuisance. If this happens, the landlord can be held responsible for cleanup and remediation costs, which creates a strong incentive to act quickly when drug activity is suspected. Removing the tenant involved in the activity is the first step in protecting the property and limiting the landlord's liability. The eviction process in Mississippi is notably fast. The landlord files a complaint in justice court, and the court can schedule a hearing within a few days. If the court rules in the landlord's favor, a writ of possession is issued, and the sheriff carries out the eviction. The overall timeline from filing to physical removal can be as short as 2 to 3 weeks in many Mississippi jurisdictions, one of the fastest in the country. Mississippi's court system for evictions is straightforward. Justice Court handles the majority of residential eviction cases, and the proceedings are relatively informal compared to higher courts. The landlord presents evidence of the grounds for eviction. The tenant has the opportunity to respond, and the judge makes a ruling. The process is designed to be accessible without requiring attorney representation, though having legal counsel is always advisable for complex situations. If the tenant appeals, the case moves to county court for a trial de novo. During the appeal, the tenant may be required to post a bond to remain in possession. If the tenant doesn't post the bond, the landlord can proceed with the eviction even while the appeal is pending. This requirement helps prevent tenants from filing frivolous appeals solely to delay removal. On the tenant side, Mississippi provides limited grounds for early termination compared to more tenant-protective states. If the landlord fails to maintain the property in habitable condition, as we covered in our Mississippi habitability video, the tenant can pursue remedies through the courts, including constructive eviction if conditions are severe. However, the available remedies are more limited than in states with detailed statutory tenant protection frameworks. Active duty military members are protected by the Federal Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. Mississippi has several military installations, including Keesler Air Force Base in Biloxi, the Naval Construction Battalion Center in Gulfport, and Camp Shelby near Hattiesburg, making this provision relevant to a significant number of tenants in the state. Mississippi does not have a comprehensive state statute providing early lease termination rights specifically for victims of domestic violence. This is an area where Mississippi lags behind a growing number of states that have enacted such protections. Tenants who are victims of domestic violence and need to terminate a lease early should consult with a local attorney or contact a domestic violence advocacy organization for guidance on available options under current law. Mississippi strictly prohibits self-help evictions. Landlords cannot change locks, shut off utilities, remove the tenant's belongings, or take any physical action to force a tenant out. All evictions must go through the court system. While Mississippi doesn't have the elaborate statutory penalty provisions for self-help evictions that some states impose, a landlord who engages in self-help faces civil liability for the tenant's damages and undermines any legitimate eviction case they may pursue. One practical consideration for Mississippi landlords: because the state's legal framework is relatively light on statutory detail, the lease agreement is your most important document. Everything that the statute doesn't address, notice periods for violations, cure rights, grounds for termination, maintenance responsibilities, and the consequences of specific breaches, should be clearly spelled out in the lease. A well-drafted lease customized for Mississippi law gives you the tools you need to manage the landlord-tenant relationship effectively and to enforce your rights when termination becomes necessary. Mississippi's climate creates additional practical considerations for the termination timeline. The Gulf Coast region is vulnerable to hurricanes and tropical storms, which can disrupt court operations, delay eviction proceedings, and create emergency housing situations. During and after major weather events, courts may suspend eviction proceedings temporarily, and both landlords and tenants may need to navigate property damage issues before the termination process can proceed normally. Mississippi requires landlords to return the security deposit within 45 days of the tenant vacating the property. The landlord must provide an itemized list of any deductions. If the landlord fails to return the deposit or provide the itemization within 45 days, they may forfeit the right to retain any portion and could be liable for additional penalties. Mississippi's 45-day window is one of the longer return periods in the country, giving landlords more time to assess damage and obtain repair estimates. For the complete guide to Mississippi lease termination laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our series.